Morning, everyone. Thank you for joining. We're just going to give a few more minutes for everyone to join in, and then we'll start at exactly 11. Good morning, everyone. Imagine this. You wake up one morning, just like any other day, you hug your loved ones, head to work, and life carries on as usual. But what if that was your last day? None of us like to think about it, but life can change in an instant. Have you ever wondered what would happen to your family, your children, or your hard-earned assets if you were suddenly no longer here? We see these things or hear about them more often than we would like to. Young people dying, old people dying, they're sick and they're healthy. There's a Zulu saying that says, which translates to death chooses anyone at any time, the young and the old alike. Now picture this. Your family, already grieving, is forced into difficult conversations. Extended family members are involved, legal battles, and financial uncertainty, all because you didn't leave a will behind. They don't know your wishes. They are left to figure it all out on their own. So this isn't just a legal issue. It's a deeply personal one. Creating a will isn't just about money or property. It's about love, protection, and making sure that your family is taken care of even when you can't be there for them. So today we are going to talk about how a simple document can give you peace of mind and, more importantly, protect the people you care about the most. The NMG Wills and Trust invites you to join us for this presentation on the importance of a will. We are going to spend about an hour with a 50-50 split. First half of the presentation being the actual presentation on the importance of drafting a will. And then the second half of the presentation will be the creation of your will. So what's going to happen is I'm going to be explaining on my side our user-friendly portal, which you'll be using to create your will. So as I'm presenting, you are also simultaneously going to be creating your will at the same time, so that by the end of the presentation, you will have created your will and completed it online. My name is Pumlani Piti. I'm a benefit counselor from NMG Member First Division. I'm not here alone. I'm here with my team who are logging in online, who are going to be assisting as you are going to be answering questions. So if you have any questions, feel free to ask them. So you can only ask questions on the chat. So there's a question and answer chat box. That's the only way you can ask questions. So meaning that you can't use the mic to answer questions. But if you do have questions, make sure that you type them in on the question and answer, and they will be answered immediately. So without wasting any more time, this is our agenda for the presentation. So by the end of the presentation, we should all know what estate planning is. We should all know what a will is. And then second half of the presentation, we will make use of our Will It Be solution, which is our Will It Be platform. And I'll be explaining it step by step. Take steps now to make the experiencing of your passing as easy on your family and loved ones as possible. So what is estate planning? Estate planning means making a plan for everything you own and everything you owe. Anything of value like property, cars, jewelry, and investments. It entails these three main ideas. The first one being making sure that there is enough liquidity. So estate planning ensures that there is enough liquidity, which is money to cover debt, estate duty, capital gains tax, and other expenses related to your debt. Secondly, estate planning entails that there is enough funding. So enough money left for your dependents' maintenance needs. And then lastly, estate planning entails that there is enough planning. So drafting a will is part of estate planning. Think of a will as instructions you've given on how you want your assets to be distributed after you've passed on. You need to make sure everything is settled once you've passed on. So what is a will? So a will, first thing foremost, it's a legal document. So a will is a legal document. What does this mean? This means that a will is backed and supported by courts, right? Making it impossible or very difficult to dispute whatever is written in it, right? So giving you the assurity that whatever you've written, whatever your wishes are, they will be followed accordingly. So it's a legal document that specifies how a person's property and assets will be distributed after his or her death. And then secondly, a will is a document that grants you freedom of choice. from your funeral arrangements all the way to the actual distribution of your assets. So it will reflect a person's wishes, desires, choices, or intentions. And then thirdly, and most importantly, you get to nominate guardians. So this is very important to me because a lot of the times when we ask people who don't have a will, their common excuse would be, I don't have a will because I haven't accumulated enough assets to create a will, right? So if I were to pass on, there isn't much that I'm going to leave behind for the people. So why create a will? So come back to me after a few years, a couple of years, maybe I'll have a thing or two, and then it would make sense for me to create a will. But then when you start having a conversation and listening to this person, you realize that this person is a single parent. They're raising these two beautiful children who are still minors, and they don't have a plan in place as to who's going to take care of the children in the event where they pass away, right? They have hopes that their parents or their siblings would be more than happy to take them in, but then that's not always the case, right? So it's very important to plan for these things, right? It's not just assets, as I've stated earlier, it's not just assets, but it's also the people that you leave behind, your children, most importantly. So a will grants you that option to then nominate guardians. And then fourthly, a will needs to be valid. So like I stated earlier, a will is a legal document. So with that comes the fact that it has to be valid, right? It has to be valid. So there's certain requirements that have to be put in on the will for it to be recognized by courts and be able to be executable, right? So a will just, I will get into detail as to what exactly are the requirements of a valid will. But then just briefly, a will must be written or typed, signed, and witnessed to be valid. So by leaving a will, you avoid having loved ones fight over your assets. Now let's talk about what happens if you die without one. What happens if you die without a will? So the process that's gonna be in effect is the Interstate Succession Act, right? So what is this Interstate Succession Act? The Interstate Succession Act is an act by the government for people who pass on without leaving a will behind. So it's basically a structure or a guideline as to how the person's assets will be distributed among the people he or she leaves behind, right? So it's a structure that came about by the government to decide for you, since you obviously didn't decide for yourself because you didn't leave a will behind. So it's a way for the government to decide for you to say, all this person's assets must be given to so-and-so in this sort of structure. So the Interstate Succession Act would, for example, look at your descendants firstly, put them first. So they will be the priority. But if you don't have descendants, then they will look at the following, which is your parents. And if you don't have parents, they will look at your parents' descendants, which are your siblings, the deceased siblings, right? So in that structure, in that manner. So it works, but obviously it's not a one size fits all, because you may not want that structure to be followed. You may have a different structure that you had in mind. So another flaw that comes with the interstate succession is that it doesn't look into more details as to the family structure, right? For example, let's say you pass on today, you leave behind two children. One child is still in primary school, and then the other child is already working, already surviving by their own. The Interstate Succession Act won't look at those details as to when it comes to the distribution. It will distribute equally among these two children, which means 50-50. But then obviously, if you were alive, or a normal person would obviously give more to the child that is still in school because they're still young. They need the money more, or they need the assets more than the child that is already grown and already surviving by their own. So the Interstate Succession Act doesn't look at those small details that come in that differ from family to family. So following the PHE decision, all estates must now be administered according to the Administration of Estates Act and distributed under the Interstate Succession Act 1987, Act 81 of 1987. These laws ensure that women and children have equal rights to inherit, promoting fairness and equality in estate distribution. So this means that if you die without a valid will, your estate will be divided according to a set formula, which means that dying without a will is equal to interstate succession, which is equal to division of your estate with a set formula. So now I'm going to share two stories. The first story is of Uncle Kaya and his nephews. So Uncle Kaya, a devoted godfather and caregiver, had taken in his two godchildren after his best friend passed away. For years, he raised them as his own, providing support, love, and a stable home. He always intended to leave everything to them. Unfortunately, Uncle Kaya passed away suddenly without leaving a will behind. Despite being the only father figure his godchildren had ever known, the Interstate Succession Act did not recognize them as legal heirs. Instead, Uncle Kaya's estate was distributed among his distant relatives, leaving his godchildren with nothing and facing uncertainty about their future. So what is the lesson from Uncle Kaya's story? The lesson is that a will ensures that the people you care for and consider family are recognized legally and can inherit according to your wishes, regardless of formal legal relationships. The second story is in Zulu. It's about uNkosazana Dlamini. uNkosazana Dlamini ongumama oyedwa wezingane ezimbili ezivela koyise abangafani. Ithemba lakhe bekuwukuthi ifa ekazolishiyela abantwana bakhe lanele izizukulwana nezizukulwana. Inkinga ukuthi ukufa kuvele kwamhlasela engakubhali konke lokho phansi, engakabhali iwill. Izingane zakhe azivumelananga ngendlela kuzophathwa ngayo ifa lakhe. Ngaphansi komthetho we-interstate succession, ifa lahlukaniswa ngokulingana. Kodwa lezi zingane zazinemibono ehlukile ngalokho okufanele kwenziwe ngofanelwe yifa. Lokhu kwabanga ingxabano phakathi kwabo eyathatha iminyaka. Baze bagcina sebalahlekelwe ibhizinisi lomndeni ngenxa yokungakwazi ukubambisana. Sithini isifundo? Isifundo sithi ukushiya iwill kungagwema izimpi phakathi kwezihlobo futhi uqiniseke ukuthi izifiso zakho ziyalandela. So now I'm going to share a few examples of a family structure that you may find yourself in the event where you pass away and in the event where you pass away without leaving a will behind. So just a reminder, you can't ask questions using the audio. So the only way you can ask questions is if you go to the question and answer chat box. So there is a chat box and then you need to type your question there. So you type your question there and it will be answered as soon as possible. So the first example is if the deceased is survived by a descendant or descendants, but not by a spouse. So in this event, the Interstate Succession Act will then distribute everything equally among the descendants that are left behind. The second example is if the deceased does not leave a spouse or descendants or parents, but both his parents left descendants. In this event, the Interstate Succession Act will come in and everything will be split equally among the parents' descendants, which are the deceased siblings. And then the last example that I want to touch on is what is the position with regard to an adopted child of the deceased. So adopted child is recognized legally, and that shouldn't be an issue. Everything will then be split equally among the adopted children because it was a formal adoption, unlike the situation that I had mentioned previously, Uncle Kaya's story, where the children are adopted, but nothing was made legal or nothing was signed, nothing was formal. So in that event, unfortunately, those children will not be regarded as adopted children. So what are the requirements for drafting a valid? So like I said earlier, a will is a legal document. It is a contract, right? And just like any other contract, there is certain requirements that have to be met in order for the contract to be recognized by the law, right? So these basic requirements are contained in Section 2, subsection 1A of the Wills Act 7 of 1953. First requirement is you must be 16 years and older to draft a will. Second requirement is the testator or testatrix, testator being the male person drafting a will, testatrix being the female person drafting a will, the testator or testatrix signature at the end of the will, recommended just below or as near as possible to the last line of the will. Thirdly, the will must be in writing, handwritten or printed, and don't forget to put your name on it. So, like I said earlier, we are going to be creating your will online. So you are going to be creating your own will, and I'll be explaining on my side each step of the way. But then after creating your will online, that's not the whole story. So your will is not yet valid. It first needs to be printed out, signed, and witnessed for it to be 100% valid, right? So the original copy that has been printed out, signed with a wet signature, not an electronic signature, and also witnessed by two different witnesses, older than 14 years. So a witness can be anyone older than 14 years. And the person who's witnessing doesn't need to see the contents of the will. So if that part of the requirement has not been met, unfortunately, your will is not yet valid. So make sure that after finishing drafting your will online, make sure you print it out, you sign it, you get it witnessed. So the last requirement is you must be mentally capable of understanding the consequences of your actions while drafting a will, right? So those are the four requirements of a valid of a will. So make sure that all these are met and your will then be valid. So with that said, even a meaningless oversight may invalidate the entire document. Even a meaningless oversight may invalidate the entire document. Unfortunately, if these requirements are not met, you are the same as someone who doesn't have a will to begin with. Because what will happen is you pass away. Does this person have a will? Then the will gets pulled out. But if these certain requirements are not met, unfortunately, anyone can dispute whatever is written in it and say, you didn't write it, someone forged, and whatnot and whatnot. So make sure that all these requirements are met. So the court is given a power to condone a will that does not comply with all the formalities. So it is always advisable to check and do everything carefully in order to avoid any complications and delays. So now we've reached the second half of the presentation. So now you get to create your will online, right? So you get to create your will, draft your will online, and then afterwards, get to download the PDF document of your will, and then have it printed out, sign it, have it witnessed, and have a valid will. So what I'm going to need right now is everyone to open their browser, open your internet. I'm going to give you a website. So this website is called the Will It Be platform. That's where you'll be creating your will. So what's going to happen is I'm going to be explaining every step of the way so that as you are creating your will, I will also be explaining as we go along. So I'll be a bit slow in this section. If you feel like I'm moving a bit too fast for you, or you feel like you are lagging behind, feel free to stop me or to say I'm moving a bit too fast and that I should go back to a certain step, and I'll be more than happy to do that. So this is the website right here. So on your internet, on your browser, type in www.nmgwills.co.za. You will leave this workshop and able to leave your legacy with dignity. we'll utilize this website specifically developed for you to make the process simple and easy. So the way it's been created is so that you create your will in less than 10 minutes. And those requirements that I mentioned earlier, you get to meet them. You get to meet a few of them as you're creating your will. So that's the nice thing about this platform, is that already you get to meet certain requirements that are required for a valid will. The website is compliant with South African law. You are able to access a secure document vault that will save every version of your will, as well as other important documents that you upload for storage. So on the actual portal, you'll be able to also upload important documents to say, maybe you have important documents like insurance documents, maybe title deeds and all those sort of things. You can also upload them so that they are safe and secure with your will. So just to check, was everyone able to type in the website, and are you all able to land on the landing page after typing in the website? So just a yes or no on the chat box will do, just to see if everyone was able to type in the website and was able to see the landing page. I see yes, yes. Web page blocked. So for web page blocked, not 100% sure what the issue could be, but from my experience, it's probably the Wi-Fi that you are using. So usually company Wi-Fi's, they block out certain websites. So make sure that that's not the case. But then if you sort that out and it still persists, feel free to email us. So I am going to share our email address to send us an email to say you couldn't draft your will online because you had technical issues, and we'll be more than happy to assist you. It is company Wi-Fi, yes, just as I thought. So make sure that you either switch to a different Wi-Fi, personal one, or hotspot yourself. And if it still doesn't work, send us an email and we'll be able to assist you. So what is this will be solution? So NMG has officially launched wills through NMG Wills and Trust website. We are on a mission to, one, change the stats of South Africans that have valid wills in place from 1 in 6 to every one of our members. Secondly, to encourage financial planning and educate all our members about the importance of having a valid will. Step one. So step one, you get to create your will. So after landing on the landing page, you need to click on don't have an account. So you click on don't have an account, and then this will direct you to the sign up page where you populate all your details. That is your name, your email address, your surname, your ID number, your password, and for you to confirm your password. Then after, you get to click sign up. So if you are having troubles, technical issues, this is our email address down here. Send us an email and we'll assist you as soon as possible. So please remember your password, so that the next time you come back to this website, to this portal, to maybe update, edit, and whatnot, you are able to do so freely and seamlessly. So just make sure that you remember your password so that you'll use it in future to log in and update wherever you need to. Step two. So step two is your personal details. So the system will ask for your first name, for your surname, your ID number, your email address, your mobile number, your physical address. And then where it says membership code, where it says membership code, please type in free-sept in small letters, as seen here in red on my left. Free-sept. That's the membership code. This is to show that you created your will or you drafted your will during the September Wills Month, and your will, the drafting of your will as well as the storage will be free of charge. And then where it says current advisor, feel free to choose me or choose anyone that you see there. And then where it says marital regime, we have 3 different ones. So the first one is either life partner. So life partner, you live together, but nothing formal has been signed. Basically, you're not married, but you live together. In community of property, this is the most common one. You married, you and your spouse share everything equally. Out of community of property can either be with accrual or without accrual. Out of community of property with accrual means that everything that you've accumulated after getting married is shared equally with your spouse. And then out of community of property without accrual means that what's yours, it's yours, and what's mine is mine before getting married and after getting married. So make sure you choose the right marital regime that fits your situation. And then we move on to step 3. After doing that, you then click next. So step 3, spouses and children. So I've already touched on the different marital regimes. And then here you also get to nominate your children, right? Very important. If your children are minors, meaning they are under the age of 18, you need to nominate a guardian for your children. So you need to nominate a guardian for your children. If your children are still minors, make sure that you choose someone you trust, someone who's responsible, and make sure that you notify that person that you've made them guardians for your children, so that they are not caught unaware in the event where you pass on and they are being notified that they are guardians. And also so that they are prepared, right? Financially, mentally, right? Make sure that you notify them. And then step 4. Step 4 talks about joint executorship. So what is an executor? An executor is a person or a company that will execute your will. So in the event where you pass on, these people make sure that your will whatever your wishes are, they get followed. So everything that you've specified. So basically in the winding up of your estate. So they come in to make sure that all your wishes are met and everything is distributed accordingly. All the expenses are paid for, you know, the tax and all those things. So that's what an executor is. So NMG is the co-executor for you, since you're creating your will on the NMG Will It Be platform. But you see, we encourage you to get your own person that you trust to also be an executor. It can be a family member, it can be a friend, or if you have a lawyer, you can also include them to be an executor. So that there will be a joint executor, will be a co-executor together with NMG. So in the event where you pass away, they will assist in the winding up of the estate. So whether you choose someone or you don't choose someone, NMG will be involved. But in the event where you say you're okay with NMG taking care of everything, NMG will make sure to be as transparent as possible to your family members, right? To make sure that they understand all the tax that comes in, all the fees, you know, all the expenses that are incurred during the winding up of the estate. So if you have a joint executor in mind that you want to involve, make sure that you go here and you say yes. And if you don't, click no. So in terms of execution, for estates valued more than 250,000 in value. So your estate, which means your assets combined with your income, maybe your income meaning your money in the bank, say your investments, you know, all those sort of things. So combined your estate, if it's less than 250,000 rands in value, then the master of the high court, or sorry, if it's more than 250,000 in value, then the master of the high court will issue a letter of executorship, and a formal appointed executor will manage the estate. So if your estate is valued for 250,000, for more than 250,000, then the master of the high court will issue a letter of executorship, and a formally appointed executor will manage the estate. But for estates valued at 250,000 rands or less, the master issues letter of authority in section 18, subsection 3 of the Act. In these cases, an executor is not formally appointed, and a simpler process applies to the administer the estate. So if your estate is less than 250,000 or less, then you don't need to formally appoint an executor, but then you still need to go through the court to get that letter of authority. Whoever is going to be the executor has to get that letter of authority from the court, the masters. And then if it's more than that, everything needs to be formal. Right? Now let's talk about the fees. Right. Let's talk about the fees, which is very important because, as you know, or as I've stated earlier, since it's September and you get to create your profile on the Will It Be platform. So if you get to create your profile during the month of September, then the storage of your will will be free, as well as the drafting of your will. But then it begs the question, who then pays for the cost, right? Because there's always going to be a charge, right? Nothing is for free, right? So in terms of the fees come in when it's time to execute your will. So they don't come in now while you're still alive. They come in once you've passed on. So once you've passed on, there's going to be executor fees. So with that said, the financial service industry is heavily regulated. In what sense? In a sense that there's certain percentages that cannot be exceeded by whoever is going to be executing the will, right? Whatever executor you will meet in the market, they can't exceed these certain percentages that have been stipulated by the government gazette, right? So these percentages are not more than 3.5% of assets and not more than 6% of income. So whatever executor you will get in the industry, no one is allowed to exceed these 2 percentages in terms of fees. That is 3.5% of assets and 6% of income, right? And then there's also what we call estate duty. So estate duty is tax that comes in when someone passes on and they have assets or their estate that they are leaving behind for certain people. So the government comes in and says, we have to charge tax from this, right? So that's what estate duty is. So that is 20% for estates less than 30 million. So 30% of the estate, if your estate is less than 30 million in value, 30 million rands, and 25% for estates exceeding 30 million rands, right? So with that said, estates less than 3.5 million rands in value do not attract any duty. So if your estate is less than 3.5 million rands in value, then there's not going to be any estate duty on it. Step 5. So step 5 talks about special bequests. So these are special assets we want to give to someone, like a house or a car. When thinking of these, you should take into account how you distribute it. Think about authority and ownership. So in simple terms, special bequest is a specific item, a specific asset that you want to leave to a specific someone, right? For example, out of all the out of all my estates, out of my 10 houses, out of my 15 million that I have in the bank, I want this particular house to be given to my firstborn child, right? Or out of all my cars, I want to give this particular car to my child who's still in school because they travel a lot. So they need this car more than anyone. So this specific car, I want to give it to this specific person. So that's what special bequest is. And then on the next step, it talks about bequest, which is the residue. This is what is left unassigned from special bequests, right? So you've already made the special bequest to say this specific item, I want to give to this specific person. And now you're saying everything else now that has not been assigned under special bequest, I want to split it in this kind of way amongst the people that I leave behind. So that's what bequests and special bequests mean. So if you don't have any special bequests, for example, you only have one child, right? You only have one child and you don't plan on having any children in the future. So you're saying, this one child of mine, I want them to inherit everything. So in that event, you don't need to go to special bequests. You can just say next and then go straight to bequests. And then just say everything, 100% of everything that I own, I want it to be given to this particular child of mine. So the system will gray out options not applicable to you based on the data captured. For selected options, further details may be required. So for example, if you said you were single previously on the previous steps, you won't be able to select spouse. If you said you had no children previously, you won't be able to select children, and you'll only be able to select the people that you leave behind, which parents in this event, because the person didn't choose spouse or children initially. Okay, in the event where you don't have the guardian's details, right? That's okay. You can resume when you do have those details, right? As long as you've created your profile, make sure that you get those details as soon as possible. Update your will, continue where you left off, and have it signed, witnessed, and send it to us. Or if you want to continue, you can just give a wild guess as to what they are, because I believe the date of birth and the ID number, I think the date of birth, that's where the system doesn't allow you to move forward. So just insert any date of birth and then move forward, complete your will, and then come back again though to edit once you have the correct details, and then print out the correct will or the completed will, and then sign it and get it witnessed. So now moving on to step 7. So step 7 talks about family obliteration or no living heir. So if the people that you have chosen to inherit also die, this section is where you choose someone else outside from the already nominated people, right? In simple terms, family obliteration is the event where the people you've nominated previously on the previous steps also pass away suddenly, all of them, right? So it's not a common event, but then things happen. So this is you taking precaution to say, in the event where everyone that I've nominated pass on, for example, family trip, everyone passes on, I want this specific person to then inherit everything, or these specific people to then inherit everything. So that's what family obliteration is. So these people will only inherit in the event where the people you've nominated previously all suddenly pass away at the same time. Okay, moving on to step 8. So step eight talks about my estate value. So now we're talking about the important thing now, what you're actually going to be leaving behind for the people you've nominated. So this is the worth of your income and assets. It is an estimated number. So under estimated gross value of your estate, so this is you combining your assets as well as your incomes, and giving a figure, or a number, a rent value. So this is an estimation because we don't expect you to know your worth, your net worth, right? So this is an estimation. What you need to make sure, however, is to make sure that you put in the figures as at the moment you are creating your will, right? Not your future worth, right? Because everyone wants to accumulate assets in future. You all want to be billionaires or millionaires or whatnot. Please make sure that you put a value that is close or that is that reflects what you currently have. And then under estimated liabilities of my estate, putting a figure there as well, an estimation. And then right under that, you will see estimated net value of my estate. So the estimated net value of estate will be estimated gross value less estimated liabilities. So the system will notify you if there's something wrong. That is, if your liabilities exceed your gross value of your estate, right? Because then that's a problem. It means that you won't be leaving anything behind for the people you've nominated. So in that event, let us know so that you can set up a consultation with an NMG financial advisor. So over and above having to create your will and store your will free of charge with NMG, you get to speak to an advisor, so your financial advisor. So if you have a lot of debt and you feel like everything that you own will be taken by the debt, right? Make sure that you speak to someone, you speak to an advisor. So let us know so we can set up a consultation with an NMG financial advisor. And then under that is, would you like advice on any of the following: estate and trust planning, investment planning, business planning, and funeral cover? Tick any of that if it applies to you, and you'll get advice in all of them on those ones that you've selected. So now moving on to step 9, my confidants. What is a confidant? A confidant is someone that you trust, someone who's responsible. The role of a confidant is to alert NMG of your passing, and they will access the will and or document vault. In simple terms, a confidant is someone who's close to you, someone that you trust, someone who's responsible. So their role will be to notify us as NMG in the event we pass on, right? Because remember, as I said earlier, you creating your will online here right now is not the whole story. Your will is not yet valid. So what's going to happen is, after completing it online, you're going to download it, and then the system is going to generate a PDF document, and you'll be able to see how your document will look, how your will document will look. And then what you do is you print that document out and have a hard copy, sign it, have it witnessed, and then send it to NMG, send it to us for safekeeping. So after sending it to us, then we'll keep it until the event where you pass on. But then we won't know when you've passed on. Let's say you've already left your employer, right? We don't know where you are. We don't know where you are in life. So we need someone who's going to notify us in the event where we pass on, to say so-and-so has passed on. They had a will with NMG, and now it's time to execute the will. So that's what a confidant is. So you must select at least 3 people who are close to you, can be your friend, can be your colleague, can be your family member, but someone that you trust and someone who's responsible. So what you're going to do is you are going to notify this person after nominating them. After nominating them, you are going to notify them, let them know that you've made them confidant and that you have a will with NMG, so that in the event where you pass on, they know who to go to. So you are going to give them all these details. You have a will with who? With NMG. What is our address, physical address? What is our contact details, right? What are our contact details? What is our address? And what is our business name, which is NMG? So make sure that they have this important information, and they have that information safely stored and kept safe, so that in the event where you pass on, they can easily retrieve that information and not waste time in the event of executing the will. And then step 10 talks about wishes. So this is the letter of wishes. So like I said earlier, a will grants you freedom of choice, right? To choose how you want your funeral to go, right? To choose who you want to be the people who are going to inherit your assets. So this is the letter of wishes. So in the letter of wishes, you are able to leave items which are sentimental that do not deem need to be evaluated, but are important to you to be left to a person. So if this is something that you would like to create, please make sure that it aligns to the latest version of your will so that no confusion or contradiction is created. So the first thing is funeral arrangement. So you choose either, do you want to be cremated or do you want to be buried or other? And then you select include a living will that is not to be kept alive artificially. So what a living will is you making a decision right now while you still can to say that in the event where I'm unable to make a decision regarding whether or not should I be kept alive or not artificially. For example, let's say you end up in life support, right? So if you end up in life support, you obviously cannot make decisions as to do you want to be kept there or not. Your family has to be the ones to make that decision for you, right? And that's not really a desirable situation because family members fight over these things. Quick example, two daughters, two children of this father who is now in life support, who finds himself in life support, can't make decisions, can't breathe without the life support machines. Now, these two daughters have to decide, should we keep the father um, on life support or not? One daughter was saying, let's keep the father there. He may wake up tomorrow. Who knows? The other daughter was saying the opposite. Let's not keep the father there. He may not wake up anytime soon, or he may not wake up at all. And it's taking a toll on our finances because as you all know, um, hospital bills are very high. So keeping a person in hospital can be very costly. So the two daughters couldn't agree on what should be done. Then what happened is the other daughter went behind the other daughter's back, got the doctors to pull the plug, and unfortunately the father passed on. 30 years later, the two daughters still hate each other. They're still not speaking because of that decision, right? So that's not a legacy that we like to leave behind, right? You don't want to be leaving a legacy of your family members hating each other because of a decision that you couldn't make, that you failed to make while you still could. So by ticking here to say include a living will, you are making a decision to say, in the event where I am kept alive artificially, I want the doctors to pull the plug. I don't want to be kept there. And I don't want to leave that burden to my family to decide whether I should be kept there or not. And then under that is it's include organ donation. So if that's something that you're interested in, feel free to tick there and make sure that you register with the rights organizations that deal with organ donation. And then other specific wishes. So this is where you become as flexible as you would like in terms of what exactly you want, right? So as you can see here, this is an example. I do not want after tears. Everyone must go home and rest after my funeral. So if that is your wish, it's by law, it has to be followed, right? So feel free to write as much as you want there, as specific as possible, because obviously we don't want any confusion. So let's say you have a sentimental item, you have this ring that has been passed on through generations and has been passed on to you, and you also want to pass it on to your grandchildren, great-grandchildren. You don't want it to be sold. Make sure that you specify there that this specific item of mine, I don't want it to be sold. I want it to be given to this child of mine, and he will also give it to the grandchildren and whatnot and whatnot. And then right under that is please generate my will in. So you get to choose a language. So it's either English or Afrikaans. Then after that, generate will. Step 11. Step 11 is the final step. So here you are done. Done with what? Done with creating your will online, right? Remember, your will is not yet valid, right? I need to emphasize this because I don't want you to be sitting comfortable thinking that you have a valid will, and then in the event where you pass away, you have a will that's going to be executable. Unfortunately, this was only half the job, right? So after clicking generate your will, you'll get this message from the system saying, congratulations, your last will and testament has been successfully generated. So then you can either view your will, you can download it. So when you download it, you get to see the PDF version of your will. So how it looks. And then after downloading it, you then print it out, get it as a hard copy. Secondly, sign it. The original copy must have a pen signature in the presence of 2 witnesses. Again, a witness can be anyone older than 14, and the person who's witnessing doesn't have to see the contents of the will, right? They can just come in to say, we've seen you sign your will, and we're here to sign as well. And then, excuse me, after that, you send it to the NMG offices for safe custody. So the reason why we're saying you send it to the NMG offices for safe custody is because documents get lost in the house, right? So let's say you pass on 40 years to come. You don't pass away in the next 20, 40 years. Who's to say that that will still be in the proper condition or will still be there, right? So it's very important that you send it to us. You're more than welcome to print out 2 copies. 2 copies, have both copies signed and witnessed. Keep 1 copy for yourself, and then send the other copy to us. So I will share our physical address where you need to courier your copy to, your original copy to. And then fourthly, expect the email confirmation from NMG that your will is in safe custody. So after we've received your will, what we'll do is we'll send you an email to say, thank you, we've received your will and it's in safe custody. And then inform your confidants, inform the guardians that you've nominated. So just a side note, the costs to courier your will to us is your responsibility as the member, right? So make sure that you have that sorted out. Send your copy to us. So this is our address, NMG offices, 9th floor, 19 Amishoff Street, Braamfontein, Johannesburg. So this is where you send your original copy to. And then m1@nmg.co.za. This is our email address. Send us an email just to say, hey, NMG, I've just sent you my will. Expect to receive it anytime within the next 2 weeks, just to take initiative. And then very important, on the envelope, make sure that you specify that the will is going to Member First Division. So specify as stated here. Member First Division will document. Give us your name and your surname, as well as your contact details. So this is to make sure that your will document doesn't land into the wrong hands, right? It's to make sure also that the process is seamless and you get that confirmation email as soon as possible. And then on the left here is our QR code. This will take you to our website where you'll find our contact details and our physical address. So this is the end of the presentation. Closing words: be responsible, take charge, finish your will, finish drafting your will, sign it, have it witnessed, and send it to us. Thank you all for joining and have a great week ahead.